different style than Gar does, who has a different style than Carbon does. And you know, if they had nothing, if they were totally removed from the writing process, then it wouldn't be a distinct style. That's and you see Fisher's style also, I think, consistent across both briefs. So in any event, here's the clip that I liked that I thought kind of is a decent analogy. This is from Steve Jobs, which is a good movie, but not Aaron Sorkin's best movie. Aaron Sorkin is probably my favorite screenwriter. Best Aaron Sorkin movie? Anyone?
Facebook? I don't know who.
Facebook is his second best movie
I didn't
ever.
even know
It's
he really
not
did
called
that.
the Facebook. It's called Social Network, but that's all right.
That was a guess.
The Big Lebowski.
He did not. That's the Coen Brothers. That's my favorite Coen Brothers movie. It's A Few Good Men. Has anyone seen A Few Good Men?
I haven't seen
So arguably my favorite movie of all time, but probably like third or fourth. Okay, so this is from Steve Jobs, and Steve Jobs is talking to Steve Wozniak, who helped him found Apple. Okay.
What did you do? Why has Lisa not heard of me?
Man, how many fourth graders have heard of you?
You can't write code. You're not an engineer. You're not a designer. You can't put a hammer to a nail. I built the circuit board. The graphical interface was stolen from Xerox PARC. Jeff Raskin was the leader of the Mac team before you threw him off his own project. Everything, someone else designed the box. So how come 10 times in a day, I read Steve Jobs as a genius? What do you do?
I play the orchestra. And you're a good musician. You sit right there. You're the best in your row.
So that's it. I play the orchestra. That's what I think you should think of when you read the Carbon brief or the Landau brief or the Fisher brief. They're playing the orchestra and they're not like totally removed from the writing process. But at the same time, let's not pretend that they like did all the research themselves and like started with page one and typed, except for Chris Landau who did. Okay. Other housekeeping, there's a Central High School information session on February 26th at noon that if you have any interest at all in joining our Brandeis Central High School partnership, I encourage you to at least go check out the info session. I don't know if there's pizza there or not, but hopefully they provide some pizza. And in any event, it's a great program. This is my 4th year involved in it. I'll admit this year I've not been as involved as I have been in past years, and I regret that. But that's because I'm teaching you all on Friday mornings, and so I can't be there every other Friday. Yeah, Dimitri.
What was the date? I'm
February
sorry.
26th at noon.
At noon.
Probably at 275, but I don't think they picked a rate for sure. But Central High School is a magnet school in the West End that has a pre-law program, and their students are fun to teach. There's a sophomore program, a junior program, a senior program. If you're new to the partnership as a Brandeis student, you can teach either the sophomores or the juniors. The senior program is for return Brandeis students. And the sophomore program is called Street Law. I don't know exactly what they do. But the junior program is on writing skills, and I supervise about 8 to 10 Brandeis students each year who go every other Friday to Central High School, and they teach writing skills to students. And Brandeis students, I think, get a lot out of it. They say that they do. I get a lot out of it. I enjoy it. Partly because I love the program, but also, maybe even more so, it's a chance for me to meet a few new Brandeis students who I didn't teach, but then even better, like reconnect with 2L Brandeis students who I did teach, but now otherwise would not get to see very often. So I have requested that I not have a class at Brandeis scheduled next year on Friday mornings so that I can be more hands-on than I've been this year. In any event, that's the Central High School information session. And then, last thing is homework. So Zach's on here. I'm writing myself. Ugh, so much work. Let's see. Read the brief in Sup 2 by Ted Cruz, one and only. Read. There's still a trash can, so I can just like shoot this at that. Probably this. Slightly there. Judy Fisher, back 13 to 14, and then read Garner, number 4, chapter number 4, which is about headings. So the cruise brief, and here I can tell you what section of Sub 2 it is.
Do it.
That's Brian Gardner.
Yeah.
Brian Garner, yeah. Number 5. So,
Yeah, I gotta read this.
Okay, so just make sure we're on the same page. You open your supplement 2, you look at reading number 5, it's written by Ted Cruz, read that. You look at the Judy Fisher supplement, page 13 to 14, and you look at, you're right, I left off the art. The Brian Garner book, and read chapter number 4. Okay, practice tip of the day. Let's go ahead and shut the door. I don't know where I'm showering until practice tip of the day is if in doubt about whether something can come back to haunt you, in terms of something you say, if in doubt, don't write it down. Don't write it down. Say it, don't write it down. As you may know, a lot of litigation involves extensive discovery requests where teams of lawyers will go through thousands of pages or tens of thousands of pages of documents from the other side, looking for dirt, looking for something incriminating. And that's called the discovery process, and it often involves emails. Like, discovery is so much more expensive and time-consuming than it used to be because there's so much of a written record now in terms of internal office communications compared to what there used to be. So sometimes that's incriminating, and whenever I see it, I just think, I so often think, why did you write that down? Why not just, if you want to do something nefarious, or let's not even say that, let's just something that you thought was right in the moment, but you had to have known, there are going to be people who will find this not so great. Why did you make a paper record of it? Same thing like Nixon in the White House. Why did you make tape recordings of you obstructing justice? What were you thinking? Say it, don't write it down. That's my practice tip. But I have an illustration of this from a master of almost all things, including being a brilliant lawyer, including being a brilliant writer, and also including being a, I think, brilliant political actor, and that is Elena Kagan. She, before she was on the Supreme Court, was Solicitor General in the Obama administration, and she knew that she was on a short list to be the next Supreme Court justice. She knew two things. Number one, she knew she could be the next Supreme Court justice. And so there were probably 5 or 10 people in the country who had a real shot at being the next pick. She was one of them, and she knew that. And then she also knew that the Affordable Care Act was going to be challenged in court, and that ultimately its fate could hinge on a decision by the Supreme Court on whether it was constitutional or not. So she knew these two things. And so then she surmised a third thing, which is she combined it. If I'm on the Supreme Court, I want to be able to vote on the constitutionality of the ACA, of Obamacare. And if she was involved in Obamacare as a member of the administration, she would be recused from considering it if she ended up on the Supreme Court one day. So she wanted to avoid being recused. So what does she do? Look at this. I love this email exchange. There's 2 of them, actually. Here's the first one. Subject is healthcare defense. Let's see if we can zoom in here. Here we go. So she gets, a little hard to see, she gets an email from Neil Katyal, who received this email. Tom wants to put together a group to get thinking about how to defend against inevitable challenges to the healthcare proposals, and hoped that the Office of the Solicitor General could participate. Could you figure out the right person or people for that? More the merrier. Here's hoping we meet next week if we can. So that goes to Neil Katyal, who's Kagan's deputy when she's Solicitor General. And he forwards this to Kagan, and he says, I am happy to do this if you are okay with it. Otherwise, Ed would be the natural person, or both of us. What does Kagan say? Does she say, hey, the more the merrier, I'll join the meeting too. Let me get involved in the Affordable Care Act strategy, and then I'll be recused when I'm on the Supreme Court one day. And then it'll be a 4-4 tie instead of a 5-4 we win, which is ultimately what happened. So what does she say? She doesn't say the more the merrier. She doesn't say I'll join the meeting. She says you should do it. So don't, stay out of it. Stay out of it. Avoid. But then, this is the paper trail part. Later, I don't know if what he was thinking, but once again, Neil Katyal gets this like long email from Tom, whoever Tom is, and it's like, hey, there's some Obamacare strategizing, blah, 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 blah. And so then you can see Katyal sends this email to Kagan, says, this is the first I've heard of this. I think you should go. No? I will regardless, but feel like this is litigation of singular importance. Now, is it litigation of singular importance? This is the constitutionality of a law that reformed 1/8 of the economy. Is it a litigation of singular importance? You can nod or shake your head. Yes, it is important. So normally, the Solicitor General would want to be involved in litigation of significant importance, but Priya and Lee are still stunned from my prank this morning. It was amazing. So they would want to be involved in litigation of singular importance. But what does Kagan say in response? Because she doesn't want, first of all, she doesn't want to be involved. Secondly, she doesn't want a paper trail that can be used against her. This is a key thing, and this is the lesson, and this is what I encourage you to do if you're ever in a similar situation where you're just thinking like, okay, could I type something that will haunt me later? And this is what you should do if you're worried about that.
It's a great one.
What's your phone number? What's your phone number? Right? And that's where the paper trail ends, right there. Who knows what she said to Neil Katyal? Who knows what he said to her? I'm willing to bet the farm she didn't go to this meeting. And in any event, there's nothing that can be used to incriminate her or haunt her later. That is a very, very cautious lawyer, a very, very cautious counselor. And she's looking out for her own interest there, but she's also looking out for a cause that she cares about. And when you're an attorney, you should look out for the client and the client's interest and be cautious about guarding the client's interest. So in any event, there's the lesson. Okay, what's next? Research. Let's talk about, it's a little hot. Hello.
Sorry.
Perfect timing. I would have thought 20 minutes ago was perfect timing, but no, I hear there was printer problem. Okay, so let's talk about research. We are in the state of Brandeis, fictional state. You can imagine it's like a 51st state, and we're saying that it's like following Indiana statutes, Indiana rules of procedure, that kind of thing. Okay. So first of all, let's start with statutes. What statutes would be controlling? Or I was expanding. What written texts, so non-court decisions, will be controlling in the state of Brandeis, according to the rules we've created? Let's make sure we're all on the same page. Yeah, Sheldon.
The U.S. Constitution.
The U.S. Constitution. First and foremost, the U.S. Constitution. Specifically, the Sixth Amendment, which has the Confrontation Clause. That is controlling law. The state of Brandeis is not allowed to ignore or defy the U.S. Constitution. I would also add, we'll pretend that the Indiana state constitution controls, Indiana statutes written by the Indiana legislature control, U.S. statutes written by the United States Congress control. But you really don't have to worry about that kind of stuff. This is a case about what the Sixth Amendment means. So, aside from maybe a procedural thing here or there, or what the underlying crime was in your background, it's the U.S. Constitution that's going to be the controlling law. Now, different courts interpret that U.S. Constitution every day, and some of those courts, or at least one of those courts, is going to be controlling in our case. So, what court's decisions are binding precedent in the state of Brandeis?
Indiana Supreme Court.
No, because we are pretending that the state of Brandeis is following Indiana statutes, but it's not bound by the Indiana Supreme Court. Yeah, Leanne. The U.S. Supreme Court. U.S. Supreme Court. I know that's why we're doing this, because it's a little confusing to be doing a fictional state. It's a little bit more artificial exercise, but this is not a real case. So, I think I have plenty of confidence in your all's ability to imagine this hypothetical scenario. So yes, the U.S. Supreme Court is binding precedent. No other courts are binding precedent. Okay. What we're doing is we're kind of pretending that there's the state of Brandeis that has all the laws of Indiana, but not the courts of Indiana. Okay, so the U.S. Supreme Court is binding precedent. Kelsey, does that mean that that we should only look at decisions by the United States Supreme Court? No. And why do you say that? Because I phrased the question with a certain tone of voice that strongly suggested the answer was no? Or is there another reason?
I feel like other opinions could be persuasive.
Exactly. Any other opinion out there is fair game. Now, some courts are more persuasive than other courts. If there's like a traffic court in Topeka, we probably don't care a whole lot about what they said. But if there's a state Supreme Court, even a state intermediate appellate court, or a United States appellate court, like the Sixth Circuit, or the Seventh Circuit, the Eighth Circuit, whatever, then that is a persuasive authority. State of Brandeis, not in any particular circuit. So when you do your research, Kelsey, what kinds of, you should look for United States Supreme Court cases because they're a binding precedent, and you should look for other authorities that are persuasive authorities. And there's no United States Supreme Court precedent that's exactly on point. What kinds of persuasive authorities are you looking for? And I don't mean the court's names, but I mean, ideally, if there's a persuasive authority that's out there that's going to be useful, it's going to be, just let me see. Describe for me the most useful possible persuasive authority.
One that rules in my favor.
On what topic?
On testimonial evidence, like what is testimonial?
That's all. So everything you said is correct, but you can be even more precise. You can phone a friend. I know Emily's got her hand up next to you.
On point.
On point. What would make it on point?
It's about autopsies.
Yes. So
Okay.
what would be the most useful persuasive authority that you can find would be a persuasive authority that addresses the question of whether autopsy reports are testimonial for Confrontation Clause purposes, and that rules in your favor. But you also want to be aware of the ones that rule against you, because it's going to be important to distinguish them if you can. Maybe you can distinguish them by saying, let me ask that. Elizabeth, let's say there's a persuasive authority out there, which side are you on, defense or prosecution? Defense. So let's say there's a persuasive authority out there that says an autopsy report is not testimonial evidence for Confrontation Clause purposes. You can do one or two things with that precedent, and ignoring it is not one of them. What would you suggest? What are the two possibilities?
You could point out that it's just persuasive, not controlling, and find something else to counter it.
Correct. Yes. So that's absolutely fair game. Don't feel like you have to assume that every decision out there from persuasive authorities was correctly decided. You can say to the reader, this court went the other way, but it's not controlling, and it's not correct, and here's why. Right? And because these other courts say something that I like better. There's something else you can do. Yeah.
You can
Sam.
talk about the circumstances of that one and why it's different from this, and so it's kind of irrelevant.
Perfect. And that's ideal if you can. If there's some fact about that case that distinguishes it in a legally relevant way from our case, then that's the better way to go. Because the court we're arguing to, the appellate court in the state of Brandeis, judges are cautious creatures. They prefer to follow and not blaze a new trail. And so if you can say to them, like, yes, there's this other court that ruled against my position, but it's distinguishable from my case. And if you rule for me, you will not be creating a conflict with that other court. In fact, that other court may well have ruled for me if the facts had been my facts. And sometimes that'll be possible, and sometimes it might not be possible. And when it's not possible, then don't be afraid to go with Elizabeth's option. Okay? So good. So Supreme Court cases, controlling precedents. You don't get to say they were wrongly decided. But none of them deal directly with an autopsy report. So this is, it's not like you're going to run into a Supreme Court case that like is a smoking gun, signed, sealed, delivered, case closed case for us. Okay, so how do we find the Supreme Court cases? Let me start with this. What's a good way to find the Supreme Court cases that are going to be the leading Confrontation Clause cases? presumably some of you have started your research already, so you may know the answers from your own experience. Yeah, Keller.
There were a few in the record, and then
Good.
also secondary sources first.
Ah, yes, that's exactly right. Start with the record, see what the lower court cited, and then go to a secondary source, a treatise, confrontation clause. If you go to any criminal procedure treatise, you're going to have a section on the confrontation clause, and the first paragraph of that section is probably going to list the 2, 3, 4 most important confrontation clause cases. And if you read a few more paragraphs, you're going to see confrontation clause cases that deal with our issue, or not precisely on point, but that deal with the question of when there's an out-of-court report, some kind of scientific report or a report created by a specialist, is that testimonial or not? And so then you use that secondary source to find those Supreme Court cases, and you go look up those Supreme Court cases, and you read them, and you learn them, and you think about
Abracadabra!
Oh, I don't know what that's for, but I'm excited.
How about that?
That was lovely.
You owe us a magic trick.
Cool, I brought a deck of cards.
Ah, so
Yes.
excited. All right,
Well,
we'll
you
keep.
asked me out that one.
You want to do it now?
Are you in the middle of a lesson?
Yeah. This is a class.
That's what I'm saying. I don't want to interrupt your lesson.
All right, we'll do the end. We'll do
Blood's
the end.
getting good.
You're in for a treat. You're in for a treat. It occurred to me a couple of days ago that Zach does so many things that are great that I take advantage of
Zach does so many things.
all the time.
A lot of them are passive.
all the time. But that he does even more things